Good morning, everybody, and very welcome to this morning's webinar on client contracts for recruiters. I do hope you can all hear. If a couple of you could just type hello, just to let me know that the sound is working. Thank you. Hi, Stuart. Hi. Thanks for that. So, hello there. My name is Louina Farrell. I'm Head of Legal Services at the REC, and I'm very pleased to welcome you to today's webinar on client contracts for recruiters, which is being presented by Bernie Payne of Liability. Bernie and I have worked together for many years, but specifically the last 2 years on IR35, and when we counted earlier this week, we've now done 45 IR35 seminars together across the country, and we've got one more to go on the 1st of December before the 2021 series starts. But today we're changing topic, and we're going to talk about client contracts. And Bernie presented us with quite an interesting stat to suggest that agencies actually end up working on client contracts approximately 90% of the time. I suppose I was rather expecting everyone to use REC contracts all the time. How deluded was I? So very welcome, Bernie, and thank you very much for offering to put this webinar on for our members. This was Bernie's initiative, and we should have, when we sent out the invites to you, or at least posted this, let you know that we will be sharing the delegate list with Bernie so that she can engage with you directly if need be. If any of you are uncomfortable with that, or certainly don't want us to share your details with Bernie, could you please let us know that? I think you can put that in the chat box first, and we can as staff pick that up, but otherwise we will be sending your details to Bernie. Apologies that wasn't on the marketing information for the webinar. This webinar is scheduled to run until 2 p.m. But having spoken with Bernie, we'd probably expect her slides for presentation to take about 40 minutes, and then we've allowed about 20 minutes for Q&A, but it's up to you guys and how many questions you want to pose. I'm not going to interrupt Bernie during the presentation unless I spot in the questions box that there is something really pertinent to what she's just said that can't wait onto Q&A, something that needs clarification at that point. So otherwise, I'm going to dip out now, hand over to Bernie, and I'll pop up at the end when I then start to facilitate the FAQs. So thank you very much and very welcome, Bernie, and I'm just going to turn off my webcam and my microphone at this stage.
Thank you, Louina. I really appreciate that intro. That was lovely. So hello, everyone. Thank you so much for attending today's webinar, which, as Louina has mentioned, is all about contracts, and specifically contracts between a recruitment agency and its clients. So I'm going to be going through some slides initially, and then we'll have a Q&A session at the end. You will need to submit questions through the chat box because there isn't the functionality in GoToWebinar for kind of interactive questions. So apologies about that. So who am I and why am I delivering this webinar today? Well, as Louina's mentioned, my name is Bernie, and I've worked in legal and compliance roles within the staffing industry for over 15 years now, and I've been responsible for all of the legal, contractual and compliance requirements for both small and large agencies, which means I have drafted, reviewed and negotiated many, many thousands of recruitment contracts. So I hope that gives you some comfort that I know what I'm talking about. I now work as an independent consultant and support a variety of recruitment businesses on all types of legal and regulatory matters, including, as Louina mentioned, the dreaded off-payroll rules. Thankfully, that's not the main topic for today, but fair warning, I do make reference to it in these slides a couple of times. So let's get started. All agencies have standard terms and conditions for perm, for temp, for clients, for contractors, and for second-tier agencies if you use them. And many agencies use model contracts from trade bodies such as the REC. Now, standard terms and conditions will generally already cover and protect you against most of the issues we'll be talking about today, though it's always worth double checking your standard contracts against some of these areas just to be sure they're definitely covered. But For many agencies, and certainly the ones that I've worked in, whether in-house as a permie or as a consultant, 90% or more of their revenue comes from non-standard client contracts. So by that, I mean the client has given you their contract to sign, not the other way around. So it's important to know some of the key areas to look out for when reviewing these non-standard T's and C's, because they generally won't carry the same protections for you that your standard contracts will. I'm not going to be covering contractor contracts today, but if you do have any specific questions, then I can answer them in the Q&A. So these areas listed on the slide here are the main things to consider when you're reviewing non-standard T's and C's from a client. And I'll be delving into each of these in turn. But some of them I will cover off quite quickly. So please do ask in the Q&A if you want more information on an area that I've skimmed over. Perm T's and C's, as we know, are generally lower risk than temp. So it's temp that we're really going to focus on. But the vast majority of these considerations are important for perm placements as well. Before I move on, one thing I really recommend is putting together a summary document for all non-standard client terms that you sign up to. It should highlight how this particular contract differs from your standard client T's and C's, whether that's in terms of additional requirements or risks or different processes or whatever. And the headings of the document will probably be quite similar to the areas listed on the slide because they're generally your main risk areas. So once the contract is signed, the summary document gets filled in and then shared with all functions across the business: sales, finance, compliance, etc. And then it's saved on the client record of your ATS or CRM, if you have one, for anyone to refer to in the future. Now, the summary document should be written in clear language, so it's not just a question of copying and pasting clauses, because nobody will read them or understand them. So it needs to be accessible from a language perspective, so that each team knows exactly what they need to do to comply with these non-standard requirements. So let's get into the detail then. First of all, what is the contract for? Is it specifically for recruitment services, or has the client just given you a generic set of their purchasing conditions, which may not be appropriate at all for the supply of candidates or contractors? Some clients even issue T's and C's that relate to the provision of goods rather than services. And although it's tempting to agree to use them because they're so general and therefore don't have any specific obligations relating to your services, actually ambiguity in a contract should be avoided, and not knowing who's responsible for what under the contract, well, that can work against you just as often as it might work in your favour. Secondly, do the terms cover perm placements, temp placements, or both? You know, your risks are very different depending on the type of services you're providing, so always make sure that that's clearly stated. Now, just as a sidebar, whenever I talk about contractors in any of these slides, I'm referring to all types of temporary workers, whether pay-as-you-earn, umbrellas, PSCs, whatever. The next thing to look at, is it a framework agreement that allows for multiple placements or assignments under one general set of terms, or is it a contract for a one-off engagement? You might be more inclined to agree slightly more unfavourable terms if it's just for one placement. But if you continue to engage with that client for more roles in the future and they keep sending you the same T's and C's, then it gets a bit difficult to negotiate because you've established a pattern of you accepting their terms. Particularly in contracts for temporary recruitment, do make sure that the description of the services that you are responsible for is recruitment, not the types of services that contractors will perform for the client, such as engineering or IT services or fruit picking or whatever. That is really important, particularly when it comes to liabilities. Another question to ask is, Have you signed terms and conditions with this client before that were similar? Were there any issues under the previous contract? Ask the recruitment consultant who's been dealing with that client. And if problems have come up before, well, then you can try to negotiate the new contract accordingly. But just because you've signed similar T's and C's with that client previously, please don't just sign new ones without a detailed review, because changes to your risk profile or legislation, or even your internal processes, might mean you're more exposed or at risk than you were when you signed the previous contract. Now let's look at duration and termination. So do always check the duration of the contract. If there's a specified end date, make sure you monitor that and you start negotiating new T's and C's well in advance of expiry. And I always recommend setting up a calendar reminder, kind of 3 to 6 months before the contract expires, depending on how important the client is to your business. If it's an open-ended contract, which means it just continues indefinitely until one party actively terminates it, then just bear in mind that things change over time, especially legislation and regulation. So what you might agree to now, quite happily, isn't necessarily what you'd agree to in 3 years' time, for example. So for those terms and conditions, do keep reviewing them over time, even once they've been signed. I would say at least once every 2 years. Also look at the termination provisions. In what circumstances can you or the client terminate the contract, and for what reason? Can you or the client terminate for no reason, just because you want to? And that's called termination for convenience. Or does there have to be a reason for termination? Does someone have to have done something wrong, which is called termination for cause? Often client contracts will allow them to terminate for convenience and for cause, but only allow you as the agency to terminate in really narrow and specific circumstances. Then you need to look at notice periods for each type of termination and make sure you understand any differences in notice periods for terminating individual assignments versus the main terms and conditions. And finally, always check which clauses survive termination or expiry. You'd be surprised just how many clauses you're still bound by even after the contract has ended. Now, I'm sure you don't need me to tell you to check the rates. That's probably the first thing that most recruiters will look at in a contract. But do be clear whether it's open or closed book pricing. Closed book pricing means the client has simply given a specified charge rate for a particular role. That means you can pay the contractor whatever it is that you can get away with, and you keep the difference as your margin. Open book pricing means the client will know the pay rate to the contractor, and your fee is calculated using a percentage of the pay rate or the charge rate, depending on whether you're using markup or margin as the basis for your fees. Speaking of which, do be sure you understand whether it is margin or markup. We use those terms interchangeably, but they are not the same. And I won't go into the difference and the detail now, but suffice to say, margin is better for you than markup. And again, if you want more information or want a better explanation, just ask in the Q&A. It's becoming increasingly common in client contracts for charge rates or margins to reduce over time. So, for example, your margin might be 15% for the first 6 months of an assignment, then it reduces to 10% for the next 6 months, etc. And I've seen contracts where over time, margins reduce to as little as 1.5%. Now, even with the economies of scale that you can get in staffing, that kind of margin is unlikely to cover your costs to payroll a contractor, particularly when you factor in consultant commission, etc. So do make sure you read those clauses or schedules carefully. Ensure you know whether and how statutory payments you're required to make or the costs to you for providing certain rights to contractors are recharged to the client or not. It's also worth checking if you're able to charge a margin on expenses. It's unlikely. Normally you have to charge expenses at cost, but it's not completely uncommon. Do let your accounts receivable team know of any peculiarities in invoice processes or timings, and particularly any cut-off times for when invoices need to be submitted to the client. If the terms and conditions specify certain invoice processes or formats, that can actually be quite onerous. And often that is not accidental, that's deliberate. Clients actually make it hard for agencies to invoice them correctly because it means they can legitimately refuse to pay the invoice because it's not in the required format or submitted at the right time. That means the client can delay payment until you resubmit a correct invoice, meaning they've essentially increased their payment terms with you. Speaking of which, payment terms, obviously important, but should be linked back to invoice frequency. So for example, if you're invoicing weekly on 30-day payment terms, then you get paid quicker for the first 2 weeks of the month than if you're invoicing monthly on 14 days. Do check what your options are if the client pays you late. Sometimes the contract will specifically state that your only option is to charge interest on the late payment and that you aren't able to suspend or terminate any ongoing assignments or indeed terminate the main T's and C's either. So that means you end up continuing to supply contractors to that client without any sense of certainty that you're going to be paid on time or potentially paid at all. Also be on the lookout for paid when paid clauses. Now, these are particularly common in contracts between an RPO or MSP and a second tier agency. So for example, you as the second tier will be paid within 30 days of the RPO being paid by the client. In theory, that's fine. But first of all, you need to know what the payments are between the RPO and its client, because that might be 100 days or more. And then you need to know if there's a pattern of the client paying the RPO late. Now, of course, the RPO can just lie and say the client always pays on time, even when they know that's not the case. But you're still better off asking the question. You particularly need to know what happens if the client never pays. What happens then? Well, normally that means you'll never get paid either. Which brings me quite neatly onto the next section about payment qualifiers. Read the terms carefully for any circumstances when you might not be paid for all time worked by a contractor or might not be paid at all. So for example, a common clause we see included in client T's and C's is that if the client terminates an assignment within 4 hours of its start because the contractor is unsatisfactory, the agency isn't entitled to any payment. Similarly, most T's and C's make payment dependent on providing evidence of a timesheet authorised by the client. But if the client doesn't authorise the timesheet for whatever reason, what does that mean? Does that mean you can't invoice them at all and you're not entitled to payment? There may be other timesheet related clauses as well, and particularly where there might be a dispute over time worked that could result in you being paid less, paid late, or not paid at all, depending on the clause wording. So again, always read those sections carefully. KPIs and service levels are also important when considering how your margin might be eroded. Firstly, if there are KPIs or other performance markers in the contract, make sure they're SMART, specific, measurable, achievable, realistic, and time-bound. Otherwise, you may find you've missed your KPIs without even realizing, because the wording was vague and you interpreted the KPI differently to your client. That happens a lot. Where the contract includes service credits, you need to be even more careful. So let me use an example. You've agreed a service level that states you have to submit exactly 5 CVs per vacancy. Now, you don't do that for all vacancies for whatever reason. As a result of failing that service level, you are required to repay to the client in the form of a service credit 1% of the total revenue generated from that contract over that quarter. Service credits can very quickly make placements for that client completely unprofitable. So never agree service levels or credits without being completely confident that you can comply with them 100% of the time. And make sure you inform the teams working with that client what those service levels and any credits are. One idea that you might want to consider is making consultants' commission dependent on those same KPIs or service levels. So at least you're not paying commission on placements that you're not making any money out of. It's a pretty controversial option, but I thought I would mention it. Now let's move on to insurance and governing law. So some client contracts will specifically state what types and levels of insurance you must have and maintain. Others will simply require that you hold sufficient insurance to cover your obligations under the contract. It's increasingly common to see client contracts that require specific insurance for cyber and data liability, and of course more recently for tax investigations and specifically the off-payroll rules. So make sure you know what you're required to have in place. Unless you've specifically bought additional or add-on insurances, your insurance will generally only cover your recruitment services, so not the services that the contractors perform, and only white-collar, office-based roles with minimal risks to health and safety. If you supply grey or blue-collar workers, or in fact any type of worker where there's a higher risk of injury or risk of damage to expensive client equipment, do make sure the contract is clear on who's responsible for any costs associated with those events. And if it's you, do check with your insurer that you have appropriate cover. I've heard a few concerning stories about agencies who assumed their insurance covered injuries or fatalities, and they therefore indemnified their clients accordingly. But actually they weren't covered by insurance and had to cover the very substantial costs out of their own pocket. If over time you expand your service lines or work with new clients in other industries, always check in advance whether you have adequate insurance cover. Standard insurance policies never cover trackside rail or platform, rig or ship-based workers. So you'll need to agree an expensive extension with your insurers if you work in any of those areas. And for any offshore placements, you'll also need specific personal accident insurance that includes medical repatriation and evacuation. Do check in the contract for what's called a waiver of subrogation. It is most common in the oil and gas industry, but I have seen it coming into contracts for lots of other industries as well. And if this is something you want me to explain a bit more about, again, please do ask in the Q&A. Now we move on to governing law. Agencies obviously contract with clients from all over the world, which may mean that clients want you to agree T's and C's that are governed by another country's laws. And that can be really risky because it's unlikely you'll have any understanding of that country's common law. So that's the system of law based on judges' decisions and in particular contract disputes. and because some jurisdictions have statutory rules that can affect the validity of certain contract clauses. And statutory rules, if they exist, will override any contractual clauses agreed between two parties. So even if you think you're protected under the contract, that simply may not be the case. Furthermore, if it's not your own jurisdiction, so England and Wales or Scotland, they are different jurisdictions, then your costs to bring or defend a claim increase exponentially. Now we move on to clauses that relate to contractors or candidates. Now we are still talking about client contracts here. This slide just refers to clauses in your client contract that specifically reference candidates or contractors. And those listed on the slide are the most common areas to check and confirm. Some client contracts refer specific clauses to be inserted or flowed down to your contractor contracts. And some agencies prefer to include flow downs anyway to offset some of their risk. Just be aware that some clauses can't be flowed down to the contractor's contract, and whether they can be will generally depend on the payroll mechanism of the contractor and whether he or she has validly opted out of the conduct regulations. Even where you do make the use of flow downs, don't forget that PSCs, so limited company contractors in particular, but also umbrellas, can simply dissolve overnight. So if you're hoping to offset your exposure by passing the risk down the chain, then just remember you can't enforce any aspect of a contract against a company that no longer exists. Always confirm the length of time that you own the candidate or contractor and make sure that's linked to conversion timescales. And by that I mean where the client wants to take the contractor on perm or move him or her to another agency, etc. There are quite a few considerations around candidate ownership, so if you want me to go into more detail, again, the Q&A is the place to do that. Where the client has specified additional vetting requirements, make sure you've accounted for additional costs, such as DBS checks, and whether these additional requirements will add time to your process, in which case, of course, that might affect some of the KPIs or service levels that you've agreed. Candidate submittal processes are definitely becoming more onerous, both in terms of time and cost. Many clients, and particularly RPOs, use vendor management portals, and second-tier agencies have to submit candidates using the portal, and it can be really labour-intensive. Now, you might have a CRM that interfaces with VMS software, and then obviously that process can be automated. But for most smaller agencies, they just don't have this capability, which means someone has to manually add candidate information into the VMS. And just to add insult to injury, plenty of clients and RPOs actually charge the agency to use their VMS portal, but they don't let you use any other method of submitting candidates. So where that's the case, you need to factor in those VMS portal costs when you're working out your margins. Do be on the lookout for clauses that dictate the types of workers you can supply to that client. Some clients don't allow the use of umbrella workers, for example. Others will tell you that they will only accept agency PAYE. With the extension of the off-payroll rules to all medium and large-sized private sector clients, it's important to have the obligations and responsibilities of each party clearly stated if they differ from the legislation. My personal view is that you don't necessarily need to add 10 extra pages of clauses that relate to the off-payroll rules if neither party is adding responsibilities or changing liabilities as they are stated in the legislation. If clients deem assignments to be inside IR35 once the off-payroll rules are live, then just remember you can force the contractor to move to an umbrella or agency PAYE model. You don't have to facilitate what HMRC calls a deemed direct payment, which is where you continue to pay the PSC, having first made deductions for tax and NICs. It is important to check that your client contracts align to an outside IR35 status if you are supplying any PSCs. So make sure you review the contract for any clauses that might undermine that, because HMRC will review the full contract chain, including your contract with your client, when they are investigating compliance with the off-payroll rules in the future. Now, we all know that contracts don't make or break IR35 status. It's the day-to-day working practices. But why would you put yourself and your client in a difficult position with HMRC of having to kind of overcome that clause when you don't need to if it was just removed? If you need any more information or guidance about the off-payroll rules, the REC is hosting virtual seminars between now and April, all about this very subject. I am one of the presenters for all of the events, and my session focuses on the kind of practical and commercial considerations for agencies. Right, moving away from off-payroll rules and back to today's main topic. Always try to negotiate out clauses that make you responsible for the acts or omissions of contractors. So by that I mean things that contractors do that they shouldn't, or things they don't do that they should. And the same goes for the conduct or behaviour of contractors whilst on assignment. So that means you should be excluding your liability for any negligence, dishonesty, misconduct, or lack of skill on the part of the contractor. As a recruitment business, you are responsible for sourcing and payrolling contractors. And yes, of course, you're required under legislation such as the conduct regulations to undertake checks and ensure the suitability of candidates and contractors that you introduce. But that legislative obligation is much less onerous than agreeing in a contract with a client to be responsible for the acts, omissions, or conduct of your contractors. You know, the latter goes much further than your legal responsibilities. From a commercial perspective, even if we look at a worst case scenario, right, consider the impact of failing to comply with that suitability obligation under the conduct regs. Now, I'm not suggesting for a second that it's okay to breach the conduct regulations, but if for some reason you accidentally place a completely unsuitable contractor as a one-off mistake, and the government department who monitors recruitment agencies, the Employment Agency Standards Inspectorate, somehow finds out. Depending on the role that you place the contractor in, probably the most that will happen is a fine. If, however, you've agreed to be liable in a client contract for your contractor's actions and behaviours, the client can sue you for any losses they incur as a result of that contractor's conduct. And that is much more damaging to your business in terms of both time and cost. If the client contract requires you as an agency to ensure that a contractor puts right defective or unsatisfactory services at their own time and cost, then you need to bear in mind that either you can only use contractors who have validly opted out of the conduct regs, or that you'll have to pay the contractor for the time that they work putting those errors right, but you won't be able to recharge the client for those costs. Let's move on now to liabilities. So if you check nothing else in a contract, at least identify these three areas. What are you liable for? What losses are you agreeing to reimburse? And which indemnities you've agreed to. Now, I'm not touting for business here, but I would highly recommend getting external advice on liability clauses, since they are usually written in very oblique language, making them difficult to understand. And that's completely deliberate, by the way, that's not accidental. But they can also be quite difficult to find. So although there's almost a whole section on liability in a contract with a neat little heading, actually liability provisions or clauses are generally included throughout the whole document. So you need to review the entire agreement, not just that section. In terms of liabilities, what are you agreeing to be liable for? Well, generally, liabilities will arise where you breach a term or clause of the contract, though they can arise even where you've done nothing wrong at all, and I will be explaining that in a few slides' time. So when you're reviewing T's and C's, you should be as confident as you possibly can be that you can comply with every single clause and requirement 100% of the time. I can't tell you the number of times I've heard business owners say in relation to some form of non-compliance, whether it's a contractual obligation or a legislative one, well, you know, we did an okay job. Okay, we did breach, but it wasn't deliberate. Surely the court or the regulatory body or whoever, they're gonna see that. They're gonna see that we tried, and that will probably be enough. Well, that's just nonsense. Generally, non-compliance is sufficient on its own. Intention is irrelevant. And if you want me to explain how that manifests itself in more detail, again, just ask in the Q&A. You should only agree to be liable for your recruitment services, not the services that are being delivered by a contractor, because let's face it, that's completely outside of your control. So you can't possibly be confident that you can comply with those provisions 100% of the time. And that means you also shouldn't agree to be liable for a contractor's acts, omissions, conduct, or performance, as we've already discussed and covered. Next, let's look at what the liabilities are. And by that I mean, what losses might you have to reimburse the client for? If one party breaches a contractual obligation, the most common remedy is damages. Now, some contracts actually specify the amount of damages payable for certain types of breach, and we call that liquidated damages. But if there is no amount specified, then the defaulting party should pay such sums to the innocent party to put them in the same position he or she would have been in had the breach not occurred. If liquidated damages are included in the contract, just be sure you understand when they apply. So what types of breach does that clause cover? And of course, whether the amount specified is actually reasonable. If liquidated damages aren't included, you'll still need to understand what types and amounts of losses you might be responsible for. So you should look for the following three things to mitigate or minimize the extent of the liabilities you're agreeing to. The first is any exclusions of liability. So any clauses that confirm certain types of losses can't be claimed by the party. And a really common example is to exclude special, indirect, and consequential losses. And you should always try to get these types of losses excluded and only agree to be liable for what's called direct losses. The second are limitations of liability. So that's where liability is limited to certain defined circumstances. A common example in an agency's standard T's and C's is a clause that states the agency will only be liable for losses incurred by the client in the event of the agency's willful breach or gross misconduct. So that means if the agency acts in a way that is simply negligent or poor professional practice, they won't be liable for the client's losses as a result. Now, obviously, that type of clause is unlikely to be included in a set of non-standard T's and C's, but that doesn't mean that all of your liabilities will always be unlimited. The third is liability caps. So the maximum amount you are liable for in the event of a breach. but do check whether the cap is per breach or in total or aggregate. And also check if the liability cap excludes certain types of breach as well. Sometimes a liability cap may not cover absolutely all of the liabilities you've agreed to. Always align your liabilities to your insurance cover. So wherever possible, don't agree to liabilities that aren't covered at all by your insurance, and don't agree to liabilities or a liability cap that exceeds your insurance cover. So now let's look at how liabilities might manifest themselves, and we'll look at warranties first. Now, people think that warranties are really serious, and they are important, but actually warranties relate to lesser or minor terms of the contract. A common warranty example is shown on the slide here. So the agency is giving the client a warranty that all contractors have a valid right to work during an assignment. So using that example, we can see that a warranty is a promise of a certain standard, or that certain facts or statements that you've agreed to in a contract are true, but they aren't fundamental to the contract itself. If you breach a warranty, so if we go back to our example clause, you supply a contractor whose visa has expired perhaps, then you're liable to pay the client damages to offset any losses they incur by your breach. Sometimes warranties also include a requirement to kind of make good or reperform the defective services. That's your defective services. And if that's just a simple matter of sourcing a replacement candidate or contractor, well, depending on the role and skill level involved, that may be fairly easy for you to do. But other aspects of your services just can't easily be reperformed. So if there is such an obligation, just be sure you understand what it entails and that you can fulfill the requirement. Just a reiteration of one of the previous slides here, do avoid warrantying the quality of any contractor's services or their conduct, even if you intend to flow these obligations down in your contractor contract, because you will be liable to the client in the first instance. And if you can't enforce the contractor contract to recoup your losses because, for example, the PSC or umbrella you contracted with has now dissolved, then obviously you have no recourse. Next, we'll look at conditions. So these are more serious in the sense that conditions are fundamental terms of the contract. So if a party wasn't able to or wasn't going to comply with a condition, then the likelihood is that the parties would never have signed an agreement in the first place. Often, as per the example clause on the slide here, there is specific reference to that clause either being a condition or that failure to comply gives rise to a material breach. But sometimes it's not made clear how important that clause is. So you don't worry too much about whether you can comply with it. And that's a mistake. So for every clause you review, consider whether it's an essential term of the contract. And if it is, it's likely to be a condition. For any clauses in a contract, whether they're conditions, warranties, or anything else, you want to avoid wording that is broad, subjective, or ambiguous. The clearer the wording of the clause, the easier it is for you to know what you have to do to comply with it. It's not necessarily easy to comply with it, but it's easy to know what you have to do to comply. Finally, let's look at indemnities. These are generally the most onerous liabilities. And I've given on the slide an example indemnity clause that is often included in client contracts. An indemnity is a promise to pay, a promise to reimburse losses if a specified event occurs. So indemnities protect one party in a contract from suffering financial loss in relation to that specified event. But there are no limitations on what those specified events might be, So a contract can require any event to be indemnified. So in the example clause on this slide, the specified event is the client being held liable in relation to tax and NICs of a temporary worker. Indemnities take effect regardless of any fault or breach by either party. So it's different from a warranty, where generally you have to do something or not do something that breaches the warranty in order to be liable. An indemnity doesn't require you to have done anything wrong for liability to arise. And because it's a no-fault scenario, the types of losses that can be claimed under an indemnity tend to be wider than if you're claiming damages, which have some specific rules and parameters. The indemnified party, that is the party who has the benefit of the indemnity, doesn't usually need to take you to court like they would do for a damages claim, and they aren't under the same duty to mitigate their losses. They simply send you a bill for the losses they've suffered and you have to pay it. You should also be aware that you can agree to indemnify multiple parties under the same clause. So always check exactly who you are indemnifying. If you do accept indemnities in your contracts with clients, my kind of top tips to minimizing your exposure are on this slide. One of the most important points here is that you must make absolutely sure that you are in control of whether the indemnified event occurs or not. So if you give an indemnity to your client for losses they incur as a result of an AWR claim, for example, well, you're not in control of that because you need the client's input and cooperation in order to comply with AWR. So you should avoid giving them that indemnity. On the flip side, an indemnity that you will always collect 2 references for any candidate you submit to the client, well, that's in your control. If you haven't received 2 references, you simply don't submit that particular candidate to your client. Always try to get indemnities included in your liability cap if you have one. Generally, indemnities are excluded from a cap, so make sure there's clear wording to confirm otherwise. And get your insurer to review the contract before you sign it and confirm if they will cover the indemnities within your current policy. Most policies don't cover indemnities as standard, so you need to understand whether you're covered by insurance or not. Finally, the most important point, please, please don't ever agree an indemnity that makes you liable for the client's actions or inactions, because you have no control over whether the indemnifying event occurs or not. And if the client knows you're the party footing the bill, well, they're also not invested in doing their best to avoid the event occurring. It's a huge risk. And I'm going to give you an example of why. So, a common indemnity is actually the example clause I used in the previous slide, where clients include a tax indemnity in T's and C's with agencies that applies regardless of how the tax liability has arisen. And you're going to see that a lot more with the off-payroll rules coming into force in April. So if we go back to our previous slide, wrong way, you'll see that this indemnity applies for any liabilities that the client incurs for tax and NICs, for all types of temporary workers, which would include PSCs. Now, the clause is onerous, but let's face it, it's not uncommon, and lots of agencies will have agreed to clauses like this in the past. However, when we consider the off-payroll rules in particular, if the client doesn't provide a status determination statement for an assignment, or they provide an SDS but they haven't used reasonable care, or they've decided to take a blanket determination approach or whatever, well, they become the fee payer under the legislation and the party primarily answerable to HMRC for any tax and NICs liabilities. So the client holds what we call the legislative liability. But the indemnity in this clause doesn't specifically exclude circumstances where the client has done something wrong. It simply applies if the client incurs a liability. So that means by agreeing this clause, you've agreed to reimburse the client against all those liabilities that they will owe to HMRC. So you're therefore contractually responsible for the client's legislative liability. And when you bear in mind that, particularly in relation to the off-payroll rules, those tax and NICS liabilities can easily add up to tens of thousands of pounds per contractor per tax year. You know, that liability is sufficient to bankrupt most recruitment businesses, despite the fact that you've done nothing wrong. It's really scary. So what can you do? Well, you can walk away from that client, which is not tempting at the moment in such a client-led market. You can try to negotiate out the indemnity completely, which may be difficult. Or you can try to insert what we call a carve-out. So that is, you amend the wording of the existing clause or include a new clause that specifically states that the indemnity will only apply in circumstances where you've done something wrong and won't apply where the client hasn't complied with its own obligations in relation to any applicable tax and NICS legislation, such as the off-payroll rules. All right. Oh, I've gone through that much faster than I anticipated. So that's the end of the slides. I will stop sharing my screen and you can ask any questions.
Thank you very much, Bernie, for that. Yes, that was rather quick, wasn't it? You know, contracts are the bread and butter of what I do every day when I'm not talking IR35 with you. So I wasn't really surprised to hear you talk quite so much about insurance and indemnities, because certainly you and I talk a lot about those on our IR35 seminars. And one of the things that we pick up on our helpline quite a lot is agencies being required by clients either to have a certain level of insurance or indeed to give, you know, those really onerous indemnities. And quite often agencies, you know, tell us that the client has said, well, you know, the agency down the road will give that indemnity. We don't understand why you don't. And it's easy for us, I suppose, in our legal ivory tower to say, well, you know, don't give the indemnity. But certainly, I think, as you've pointed out, there is a real risk to a business giving an indemnity where it cannot get it insured. So I think a really important point, certainly something I would always say to members when I speak on the helpline, is you've got to make sure you run that past your insurer to make sure that they will cover the indemnity. But people didn't join the webinar to listen to me talking. So we have actually got some questions here. So bear with me. There are a few, and I will go through them one by one. Okay, I just have to read them. The font is really small on the screen. Bernie, there was quite an interesting question here, and I've actually been thinking about it the whole time you've been speaking. Are there any cases where the contract will overrule statutory law? Now, that's quite an interesting question.
I think it depends on the way that you look at it. So, as far as I know off the top of my head, contracts won't overcome or won't overwrite legislative obligations, but that doesn't mean that you can't change the obligations and responsibilities of various parties under legislation using a contract. It's not the same thing. It's not about overwriting, but like the example that I used around the off-payroll rules, if the client does something wrong and they are held under the legislation to be liable because they've not issued an SDS, for example, if they and you have agreed an indemnity in their favour, then despite the fact that they are legislatively liable, commercially you are, because you've agreed to accept and pay for their loss. So that's the kind of practical interaction more than any kind of overwriting. But it can certainly work the other way round. So a perfect example, which was quite timely, was China has statutory provisions around force majeure. So that is where you are prevented or hindered or delayed from completing your obligations under a contract, generally there will be clauses around that to say what will happen in that circumstance. But actually China has statutory laws around force majeure, and as far as they're concerned, if they issue a certificate to say that this particular company was affected by a force majeure event, then anything you've agreed to the contrary in a contract will be overruled, providing the governing law is China, of course. So that's the other reason to look at governing law.
Yeah, I mean, I suppose something a bit closer to home than China, a couple of instances that I've got. One is, for example, around the conduct regulation. So when you want to charge a transfer fee to the client, there are rules there. It's called the 8-14-week rule, or at least that's the shorthand we use, and this is the relevant period. And we've had to put a note in our contracts, for example, saying, please don't amend this because you can. That's a statutory period that's set out in law. So that's one example for, where you cannot contractually overrides that. And then another, it's not relating to client contracts, but maybe contracts with your agency workers, for example, where an agency worker cannot opt out of the AWR, the agency worker regulations. So if you even try to put something into the contract to say that they waive their rights, that wouldn't be valid at all. So Sharon, I hope that answered your question. Do come back to us if you need anything more on that one. A different topic now here from Simon. How is it best to handle late payments, and is there a recommended process you'd go by?
Well, I think to be honest, it all depends on the particular circumstances, both yours and the client's. So if the client is very dependent on you and you threatening to terminate or all existing assignments, and that's going to cause them big problems, well, then that's generally the quickest and easiest way to get them to pay up. But of course, if they say, well, the kind of workers you supply to us are a dime a dozen and we can use somebody else, then that does put you in a difficult situation. I think you would follow your normal kind of credit control processes. So usually there is a process of a reminder email, and then a formal letter, and then a more formal letter. And then you may even then put it out to a debt collector, all the way up to, whether the client can pay its bills, and whether you push for a winding up petition against them in order to get them to pay, which certainly has happened to me before, which we did with quite a large client actually. And they did end up paying. But as I said, it does all really depend just how much the money is, how big the client is, and how much they need the contractors that you're supplying to them.
Yeah, that might be one good reason to have public sector clients, because I believe in the public sector they have a code almost whereby they're guaranteed to pay suppliers, particularly small suppliers, within a certain period of time. And I would just say to REC members listening, we do actually have a legal business partner, AR Legal, who can absolutely assist with this process as well. So, when it gets to the point that you do need a debt collector, we do have a legal business partner who can assist you on that. You can find their details on our business partner page. Thanks, Bernie, for that one. Completely different topic, but of course, something that you and I talk about all the time. Do PSCs need something in writing from the client to state that it's outside IR35?
Well, for the public sector at the moment, if the client is a public authority, then they must issue a status determination statement by law, and come 6th of April onwards, so must medium and large-sized businesses in the private sector. So, but in the interim period, so if you're talking about right now, does the client need to give contractors anything? No, unless they're a public authority. But as soon as the off-payroll rules kick in, of course, on the 6th of April, then yes, the client will have that statutory obligation, that legal obligation to actually issue a status determination statement, the contents of which and what must be included are very clearly written out as well. So, they need to make sure that they comply with that. Otherwise, it's not a valid status determination statement, and therefore they retain all the liabilities under the off-payroll rules. I hope that answers your question.
Thanks, Bernie. Yes, and as I said, we do actually have one more IR35 seminar this year on the 1st of December. I think is that a Tuesday? And again, you'll find details on our web pages there. We're really jumping from topic to topic. It's almost like a legal mastermind here. Bernie, pay when paid clauses. If a client doesn't pay and we are left holding the baby, what do you suggest as a way through that impasse when negotiating the contract?
You know what? It's really difficult. It is really difficult. I mean, we talk a lot, about the imbalance of power between agencies and their clients, even though a court wouldn't agree with that. They believe that both agencies and clients have equal negotiating power, but we know that we need the client in order to make placements, which makes us money. But I think there's an even greater imbalance of power between second-tier agencies and tier-1 agencies, so MSPs, RPOs, etc., which is where the paid when paid clause tends to be most common, though by no means exclusively. And I think the difficulty is that, again, if the client refuses to pay the RPO, then the RPO has every right to refuse to pay you under the contract. The only way you can avoid that is to not agree to that paid when paid. And one thing that I've done relatively successfully, not always, but relatively successfully, is to say, okay, fine, we will accept the paid when paid clause, but we want a clause underneath it that says if the client hasn't paid the RPO by 120 days later, that the RPO will pay us anyway. Because the chances of a client not paying for one particular assignment is quite slim, which means from the RPO's perspective, the client isn't paying any of their bills. And they will have done something in that 120 days to be trying to get that money back, because that will be an enormous amount of money. So sometimes RPOs will accept that because they understand that the chances are they will have taken action to have got that money from the client by then. And there is very little risk that they will then be the ones out of pocket. And if they are still out of pocket, they can still take the risk of saying, well, let's just not pay them and make them come after us. So you can try to put that clause in that's a kind of final resort.
Yeah, I mean, I suppose, it's really not in clients' interest either that their suppliers go out of business simply because they haven't paid them. Quite important to keep on top of those clauses. A different one, again now here, going back to insurance actually, Bernie, is it okay practice to show a contract to your insurance company? Will that incur any costs, or will they do it to ensure that the correct cover is in place?
Yeah, so no, insurers won't charge you to read contracts. And in fact, a lot of insurance policies require you to tell your insurers if you sign any non-standard ones. So I think the thing is that it really depends the relationship that you have with your insurer. If you have a good, close relationship with your insurer and you've shared multiple examples of non-standard terms in the past, then they will be able to have a conversation with you to say, we know what you are agreeing to and what you aren't, so you don't need to send everyone to us. But if you don't have a good relationship with your insurer, you just renew your premiums each year and then have no contact with them, and you are signing a lot of non-standard T's and C's, that has to change. You have got to get your insurer on board. And as I said, they will not charge for looking at non-standard terms and conditions, because it is in their interests to understand whether you are covered by them or not. And of course, there is, an upsell opportunity for the insurer as well, in that, for example, you move away from white-collar office-based roles into more blue or grey collar. That's an upsell opportunity for the client to say, you're going to need these extensions or add-ons or whole new insurances. So you need to develop that good relationship with your insurer, and err on the side of caution. I would say better to send more non-standard terms to them so that they then go, it's all right, we've seen enough, just send 1 in 5, or if they are really different. But if they don't know what your risk tolerance level is, They can't give you any kind of advice about whether you're going to be covered.
Yeah, I mean, we certainly do get a lot of queries on the helpline about insurance and indemnities. And my advice is always, you've got to speak with your insurer, because ultimately they're the party who determine whether they'll pay out or not. And certainly if they don't know what it is that your risk is and your proposed liability, yeah, you really are exposing your business there, aren't you? We're certainly getting a lot of questions today about insurance. Bernie, you mentioned waiver of subrogation earlier on, and we do have a request if you could go through it. The specific point is we often get asked to add clients as an additional insured, and we see the waiver of subrogation a lot. Do you have some guidance on that?
Okay, yes. First of all, I'll cover the additional insured issue. Almost no insurers will allow a client to be an additional insured, because you aren't taking out insurance for that particular client contract. It's for any contractual liability. So generally insurers will refuse that, but they will give an indemnity to principal, usually a letter. And that is usually more than sufficient for clients. And if they don't like it, they don't, that to me is an indication that they are somewhat naive in terms of how they engage with agencies. Because, as I said, no agency will be allowed to give an additional or offer the client to be an additional insured. If the client won't accept an indemnity to principal letter or confirmation, then you've almost got nowhere to go with that, because it is as simple as that. The insurance company won't give it. Or you have to buy a whole separate policy just for that client contract, and arguably that is cost prohibitive. With regards to the waiver of subrogation, it's a little bit confusing, but it's quite complicated. So I'll give you like a layman's version. Okay, so normal insurance policies include a right of subrogation. And that means that the insurer, once they've paid you out on a claim, they have the right to then look for other parties that aren't you and their contribution to that loss. Did they also do something wrong? Were they partially at fault? In which case the insurer has a right to go after them and try and get some of that money back that they paid out to you. So it has no effect on you, but it does on the insurer, because it means that they can recoup some of their loss. But if you sign a contract that waives their right to subrogation, that means for any claim paid out, the insurer cannot go after any other party, usually obviously the client, to recoup any of that loss, even if the client was partially at fault. Therefore, insurers hate waiver of subrogation clauses, and they will almost not. Well, certainly if they don't know that you've signed a waiver of subrogation clause and you have, your insurance will not cover that contract. So if you've signed any and you've not spoken to your insurer, send them to your insurer right now, and they will be able to tell you whether they will accept that. But again, usually it is an extension to your insurances, and they will only allow a small percentage of your contracts to include that waiver of subrogation.
Okay, thank you very much, Bernie. While you catch your breath, I'm just scrolling very quickly through these to see if I can see any more insurance questions and kind of help categorize them. And if I don't spot one now, I can always come back to it. Sorry, the text is so small. Okay, Kevin, I can see all your comments. I will come to you later. I just want to get through our members' questions first. Bernie, there is one here about candidate ownership. Just bear with me a second while I have to scroll back up. Wow, we're getting a lot of questions. This is great, actually.
Yeah.
Right, Bernie, here. You offered to talk about candidate ownership. Can you give us a little bit more about that, please?
Okay, well, kind of the most sort of common ownership period for candidates, whether that's submitted for a temp or perm role, is round about 3 months. But I've seen ownership periods as short as 2 weeks. So you need to understand that, because if you've only got a 2-week ownership period, like what does that mean for any future roles potentially? You also need to look at what happens if two agencies submit the same candidate. You would assume it's whoever submitted it first gets past the post, but that isn't always the case, and it can be explained differently. And certainly if a client doesn't have an RPO but does have tiers within its own PSL, so it is a direct relationship with the client, there's no RPO there, but they tier their PSL, they prefer their tier 1 PSL providers to their tier 2s. So even if the tier 1 provider submits later, they will get ownership. So you need to read the clauses and understand what that means. Also, what happens if the client is already aware of the candidate, whether that's again for temp or perm. Also, ownership where there's been no supply. So if the candidate gets submitted but doesn't get the job that you've actually submitted him or her for, well, is the client allowed to kind of retain that candidate on file and then offer them a role in the future direct? Now, obviously, we know that conduct regs will apply, but only, of course, where the conduct regs will apply. And for a lot of agencies, who supply kind of IT or engineering or any high value PSCs, opting out of the conduct regs is 99.9% of their business. So for a lot of you, the conduct regs won't apply to those assignments, in which case you need to work out what the contract will or won't allow you to do. I think that's pretty much it. I mean, opted out contractors, you can specify longer ownership periods because those relevant periods that are dictated in the conduct regs don't apply. You can decide your own. But you've got to make sure your opt-out is valid. And that is the biggest mistake that I see most of the time. I have agencies say to me, it's fine, all our contractors are opted out. And then you check the date of the opt-out, and the opt-out was signed by the contractor and the PSC 2 days after the assignment started. It's invalid. Or it's only signed by the PSC and not by the worker. It's invalid. It's been signed by both the PSC and the worker and on time, but you didn't tell the client. Not valid. So you've got to get, if you're trying to make sure that the opt-out regulations don't, the conduct regs don't apply to things like ownership and transfer and all the rest of it, then you've got to get your opt-out process absolutely bang on. And if the worst comes to the worst, always assume the conduct regs apply. Never do it the other way around. Because if you've got any one of those things wrong, then they will.
Yeah, I mean, we still get a lot of questions actually about candidate ownership. And particularly, complaints from an agency to say, well, I sent in the candidate's details, but I know the other agency just scraped them off LinkedIn or something else and sent it over. And then you end up in what we call in legal terms, the battle of the forms. And, we always have to make it clear about, you've got to send the terms and conditions so that the client knows who they're actually engaging with. But you raised an interesting point that I wasn't aware of, which was around RPOs and the different tiers and how they might actually almost order the tiers and determine themselves who actually owns the candidate. Although I know I don't like us using that term, own the candidate, and I always start a conversation saying, well, nobody owns a candidate. We're not talking bonded labour here. But really, thank you very much also for talking about the opt-outs, because we do also still hear from the employment agency standards inspectors who enforce the conduct regulations that some agencies still don't get the process correct. And therefore, if you don't get it correct, you don't have a valid opt-out, in which case all of the restrictions and obligations in the conduct regs apply. So thanks for reiterating that one for us. I am still scrolling through all the questions. Wow, we're getting quite a lot. I'll have to keep an eye on the time. We have had contracts that cover the supply of both goods and services in one document. Obviously, the services part is relevant, but if we sign, are we then also exposed to any risks from the goods clauses?
I mean, I think, it depends on the wording, I think. But generally, those really generic purchasing conditions that cover everything that the client buys from pens all the way up to people, not that people buy people. You know what I mean? I just generally find that they're so non-specific that they're tempting, because you're like, well, we don't have to do a damn thing because it doesn't even mention recruitment. Like, that's surely easier, but actually it isn't if anything goes wrong. And I think that's the biggest problem with it for me is that just because it's not a recruitment specific contract and therefore doesn't talk about all the things that you might think expose you to risk, not having a contract that's fit for purpose exposes you to just as much risk, albeit in a different way. So I don't think you're, you know, it's not that the goods bit versus the services bit will help or hinder you. It's that a lack of tailored T's and C's can make your life considerably harder. So it's, you know, and I think there is a very strong argument to say to your client, you know, these terms are just are unfit for purpose, because there are statutory rules around, you know, candidate ownership and transfer fees and blah, 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 et cetera, et cetera. So you're better off signing our standard ones. Not saying that that will always be the case and that the client will agree, but often where we had clients who did send over generic purchasing conditions, you know, if I could have a 10-minute conversation with that client and explain to them why they shouldn't be used for either party, generally then they would accept standard terms and conditions, potentially with a few minor amendments, and then you sign amended T's and C's rather than the client's T's and C's.
You know, it also makes me think about statement of work contracts, which you and I also talk about in our IR35 seminars, and again about how they've got to be bespoke. So again, it kind of highlights, you know, the dangers of signing up to generic contracts that just don't reflect the services that you're providing. But we won't talk about a statement of works today, but again, it's just an example here. I've got a query from CJ. What would you suggest to do with COVID clauses which are unduly restrictive to the contractors, putting them in exclusive limbo in the event, bear with me, I'm reading it word by word here, so we'll have to see if we need to translate. What would you suggest to do with COVID clauses which are unduly restrictive to the contractors, putting them in exclusive limbo in the event of delays due to COVID? We are seeing these now in most agreements in the TV industry and are being commanded by insurance companies to be excluded. I'm not entirely sure I follow the question. I don't know if you do, Bernie. If you don't, perhaps, well, tell me if you do or you don't, and if not, I may have to go back to CJ and see if we can get a little bit more clarity.
I'm guessing the query, the problem, I guess, is that what your clients are asking you to do is basically the contractors can't work because they can't, you know, they can't go on site, but the client wants you to keep them and make, you know, the client doesn't want you to redeploy them elsewhere. I'm assuming that's, when you were talking about exclusive, I'm assuming that's what the problem with it is. And I think, yeah, I think that is a difficult one, but yeah, it's difficult because if you've agreed with a client that if they don't need the contractor right now, you will continue to kind of keep them warm and won't deploy them elsewhere, then that's fine. But that doesn't mean that the contractor can't just go to another agency. Because you can't stop a contractor from working. You just can't. You know, so the problem is that you might then comply with the clause because you're worried about what your client says, but that doesn't mean that the contractor has to, even if you flowed it down. You know, we know that, you know, unless they've opted out of the conduct regs, you can't restrict that contractor in any way at the end of an assignment. You can't. You can't stop them going to a competitor. You can't stop them going into the client direct. So you can't bind the contractor. You can try. You can put it in a contract, but they don't have to abide by it.
No, I mean, it's really against public policy. It's almost like the restrictive covenants provisions that you'd find in any contract of employment. You know, it's against public policy to restrict people from finding work. So I think you'd need to be very careful about that. I know we're in uncertain times and extraordinary times, but it just doesn't feel right, if I'm perfectly honest. And it's, again, easy for me in my ivory tower to say that it just doesn't feel right to say that you won't supply a contractor to other clients, even if that client doesn't have work for them because of COVID. But okay. Okay, question here from John, and I do actually, we are going through these as quickly as possible, but you've actually asked quite a lot of questions, which is great. When opening with a new client, we find very often that we're dealing with somebody sending out the client terms, but who absolutely does not understand those terms and has no interest or indeed ability in discussing them. From a practical sense, you know, how can you deal with that? Because sometimes you're just presented with a take it or leave it situation.
Yeah, I think, I've experienced that a lot as well. I think generally, depending on how the client setup is, if the engagement of new agency suppliers is devolved to HR, you generally find that quite a lot. So the HR department have never read the T's and C's. They don't care what's in them. They don't understand, you know, the clauses, and they just say, well, that's what we got given, and that's what therefore you have to sign. But then my question back to them is, well, who gave them to you? And generally it will either be their internal legal or their procurement team. And it's at that point that you say, well, can we speak to them, please? Now, if they say no, obviously there's not an awful amount that you can do. But what I would suggest is making the changes and marking up the contract and sending it back to HR and saying, I know you said that you don't understand them, but we are not accepting the terms as they are. We will accept them with these changes. And that might make them go, oh, wait, hang on, does that mean we've accepted the changes? She might then involve procurement or legal, in which case then you get your concerns looked at least. Not necessarily changed, but at least you get somebody to look at it. So I think if you kind of threaten that our track change version is the version that will apply unless and until they tell us otherwise, I'm not saying they would be binding, I'm not, but you can threaten it to somebody who doesn't really understand how contracts work. That's not best practice advice, by the way, but that's probably a good commercial viewpoint.
Okay, so this is one that is close to both of our hearts. Umbrella companies. Bernie, in your opinion, can a recruitment business pass liability under a contract to an umbrella company which they use to pay the labour which they supply? Also then, would a court uphold a claim against an umbrella company when the recruitment business is passing or avoiding liability in this way?
Okay, yes, in theory, an agency can impose any contractual terms it likes on an umbrella company in exactly the same way that a client can impose pretty much any terms on you, because it is a business-to-business commercial arrangement. Now, of course, you can ask the umbrella to do things that they shouldn't do by law with those workers, but, you know, arguably any contract with any kind of restriction within reason, providing it doesn't come under the unfair contract terms, you know, you can agree anything. The reality is, though, you know, umbrellas make small margins, and the way they make their money is huge volume. So, you know, they aren't going to sign up to really, really onerous terms in order to supply a contractor when that contractor is only going to make them, you know, £13 a week or whatever it is. So, so I think there's something to be said for that. Yes, you can always, you can, if you have legislative obligations, for example, you can flow those obligations down in a contract in the form of indemnities, etc. So all the things that we talked about today, the same could apply where you would be almost the client and the umbrella would be the agency. So you can impose quite difficult terms on them if they agree them. And if they have agreed them, then yes, of course, you can enforce that in a court, no doubt about it, in terms of losses. Your problem, though, is that the vast majority of umbrellas probably, if they're good umbrellas, they won't sign ridiculously onerous terms and conditions because there's no money in it for them. And secondly, if they're not very good and they have signed up to it, the chances are they will make an active decision to simply dissolve the company. And don't forget, that doesn't mean that they lose all of their workers. They don't. Before they dissolve the company, they simply novate all of their workers to another company with a very similar name but a different registration number, and then they dissolve. And the government is looking at, insolvency and tax liabilities, but actually they're not going to hold those directors, liable under those tax insolvency and tax liability rules, because the tax liability wasn't theirs, it was yours, and they agreed to it in a commercial contract. So, I think the thing is that the more reasonable everyone can be, the easier it is. So you can outsource your legislative responsibilities by making the umbrella pay any losses. You can't make them liable, but you can make them pay your losses. But you have no real indication of whether they will still be in existence in order to enforce that contract against. And that's always my problem. That's my concern whenever I'm dealing with umbrellas.
Yeah, I've just got a couple of points actually to add on that, because again, it's quite close to my heart here. I mean, you do mention that, the relationship with an umbrella company is a business-to-business relationship, and you're absolutely right. But interestingly, of course, under the conduct regulations, they're actually at the moment considered to be a work seeker. So although it is a commercial relationship, bizarrely, they are protected under the conduct regulations. So actually, when engaging with an umbrella company, again, the conduct regulations will apply unless you've had a valid opt-out signed by both the umbrella company and the worker. And I do know that umbrella companies quite often include the opt-out automatically within the contract, which we at the RAC have a huge problem with. I genuinely don't know what the Employment Agency Standards Inspector view of is, but certainly in our model documents, we have separate opt-outs and separate contracts. And I would just say on that point, we've actually just created a new umbrella contract for members, which you can find through the legal resources pages. And the other thing, of course, and although at the moment umbrellas are seen as work seekers or are work seekers, we know the government has committed to regulating umbrella companies, but I'm afraid with everything else going on at the moment, that just hasn't gotten through Parliament, and it's not going to happen before April 2021 either. So, if you are considering engaging with umbrella companies to help you with your payroll with regards to any contractors whose engagements are inside IR35, you've really, really got to do due diligence and understand what it is that you're engaging with. And also really important to understand what is the service that an umbrella company is giving you, because there's lots of kind of language that's thrown about, isn't it? And we get lots of calls saying, well, I'm employing the temps, but they're being payrolled by an umbrella company. I'd have to unpick that if you called me, because actually the umbrella company, a traditional umbrella company, will employ the worker. And I know there are hybrid models going around. I know I'm talking quite a bit about umbrellas, and I'm really watching the clock here, but it's something that we talk a lot about, isn't it, in our other seminars. So you have a new contract for a specifically designed to work with umbrellas if you can get them to engage on your terms. Right, just scrolling through. Just bear with me. Can you force an umbrella to accept liability for injury to workers, or would the court throw the claim out irrespective of whether they have the insurance cover or not? I thought you cannot avoid liability for death or injury. You're absolutely right, Kevin, you cannot. You see that in every contract, even in your mobile phone contract. You'll see that, and I've never heard of death by mobile phone. Maybe there is an example out there, but yes, you see that provision. It's a standard provision in every contract, isn't it, Bernie, that the parties signing up do not exclude a liability for personal injury or death. And I would say again, of course, as the employer, the umbrella bears all of the employer responsibilities towards their employees. But I do know equally, when they just see themselves as providing a payroll service, they actually try to almost abrogate all of those responsibilities and require somebody else to cover them off in those circumstances. We've got a question from Simon. When's our next IR35 session? Well, that is on the 1st of December. We're doing them all virtually, and it's Bernie and I again, and we start at 9 o'clock in the morning. So it's quite a session, going from 9 to to 2:15, depending on how many questions we've got. Is it free? Unfortunately not, Simon, but it is a very good deal. You're getting both Bernie and I two for, I think it's £75 to our members. But again, the details are on the website, and perhaps I'm speaking to my webinar organizer here. Perhaps when we're sending out the webinar slides, we can also send out a link to the next IR35 seminar, and we will be doing more in 2021. We haven't got the dates on the website yet. I think we're literally just finalizing those. Now, I'm just watching the clock because Kevin's got lots of comments here. Kevin, it's 1 minute past 2. I'm going to give you 1 minute because you've got a lot of comments in there. So I'm going to give you 1 minute, and otherwise I do hope that everybody else I've answered all of their questions. So I don't know how to allow Kevin to speak if that's the case.
You can't.
I don't know. I can't. Sorry, Kevin. I can't. I've just been told that. Yeah, it's my first time actually managing GoToWebinars, but I've been told I can't do that. But
Kevin, if you've got additional questions or queries, then my my email address is on the slides here, so you can drop me an email. Just put them all in one email, and when I get a chance, I can come back to you and respond. So you'll get a follow-up email with the slides. Probably tomorrow, maybe today, but probably tomorrow, and that will have my email address in as well. So you can just do a brain dump, and I'll be able to get back to you on them.
Yeah, I see that we did try to unmute Kevin, but it turns out he's offline now as well. Okay, I really do hope, because I was scrolling through a lot of questions, I really do hope we've covered everybody's questions. But of course, when we send out the details, your details are also on the slides as well, I'm guessing, Bernie. I presume I should have checked this, but you do contract reviews, don't you?
I do.
Yes. Some things. After 45 seminars. It is part of your service. We also have legal business partners who will also do it. But yes, absolutely, Bernie, her details will be at the beginning of her slide there. So ladies and gentlemen, thank you very much for holding on. I do hope we answered all of your questions. I must admit, I actually did find that fascinating. And I'd never heard about SMART KPIs. I've only heard of SMART in terms of PDRs. So that was a new one for me. And then your discussion about service level credits, that was actually really interesting for me as well. So really, thanks very much, Bernie. Thank you very much for all of you, and we will send out the slides as soon as we can. Thank you very much.
Thanks, everyone. Bye.
Bye-bye.